Elder law is a fairly recent section of law that has probably come about in the last 25, 30 years when people are faced with institutionalization or disability. One of the areas is asset protection planning for the family that is anticipating a potential stay in a nursing home of one or both of the parents. And that would include what we call pre-planning, so thinking ahead. And basically what that requires is taking some of the assets off the table. We use a trust to do that, where we can put the client's own assets in a trust where they can still control them, still benefit from them, still get the income off of them. But when it comes time to go into a nursing home, those assets aren't considered as available to pay for nursing home costs, thus the protection. And they can still use the assets, and when they're done using them, they can pass them on to their children. The reason we encourage people to think about planning ahead is because when you apply for medical assistance, they look at the assets that you have, and they look at the assets that you gave away in the last 5 years to determine your eligibility. So assets that you have in excess of a certain resource limit, which for a single individual is $2,400, causes them to be ineligible for Medicaid. Plus, all of the assets they gave away in the last 5 years also creates a period of time where Medicaid's not going to pay for their expenses. We want to start the gifting sooner so that we can get past that 5-year look back. But that's not the end of the analysis. There are ways to reduce the period of ineligibility and work around it and still maximize the asset protection and reduce the nursing home costs.